Well, when the world around us seems to be going insane, there's at least one sane judge in Portland, Oregon. So stick with me, folks, and we'll talk about it in a minute. Hey everybody, this is Deb with Truthfication Chronicles, and I just had to take a little bit of a sanity break, and there's nothing wrong with that. I mean, we're getting hit with a lot of crazy stuff right now, folks, and if you feel the need, take one, because it will do you a world of good, and it'll help you, maintain some roots in reality instead of hearing all the fighting and everything that's going on if you get caught up in the news process right now. And so I just kept thinking of this song. This is an old song. It's a 1980, I think 84 Randy Stonehill song, who's a Christian artist, so you may or may not have heard of him depending on what kind of music you listen to. But this song just kept going through my mind. Stop the world. I want to get off. This is too weird for me. And there are so many times when, that's what I kept thinking. It's like, stop the world. I want to get off. So I'm going to leave the link down below. I can't play it for you, sorry, because I don't want to get a copyright strike. But I do want to share it with you, so I'll leave the link down below. Hopefully it'll stay up for you. But this song right here could have been written today, and I wanted to show you one of the comments down here because I really related to this one. Yeah, being raised up on a fallen planet has some really trying moments. Okay, seasons. This planet is a tough neighborhood, and it can be, and we need to remember that we're going through insanity right now, and we need to be kind to each other because, frankly, folks, there's a lot of it out there, and it's really being used to destabilize us. I understand that we may be on opposite sides of the fence from different people, politically speaking, but let's take the time to be kind to each other, okay? So let me show you one tweet here that I thought really kind of spoke volumes. This person said, serious question, do I have to be like a mega Trumper to want to MAGA and fight you-know-who's and corruption? Like, is it okay that I don't like him, but I appreciate what he's trying to accomplish now that I've left Facebook? When I saw this, nobody had responded to it by the time I got here. But what I think is really interesting about it is that I think this person was very scared about how people would react to that statement that they may not like Trump personally. You know what? I don't care if you like Trump personally. It's not about him. It's about what we're trying to do. We're trying to take back our country so we don't completely lose it. And if you don't vote for him, this country's gone. That's all there is to it. And so I responded, but then there were others that responded too. And I liked what he said here. Thanks for love and not attacking me. Most of my friends are still asleep and don't want to wake up. So it just was amazing to me how everybody's saying, no, it doesn't matter if you like Trump or not personally. That's not what it's about. Right now, he's the only one that can preserve this fight that's going on for justice and for the rule of law to be reestablished. So if we don't vote for him, everything that has been gained in the last few years is going to be totally destroyed. And I can guarantee you that the documents that need to come out for people to see what's really happening in our country aren't going to come out if he isn't reelected. So I just wanted to share that with you because I think you need to understand that I get it that you may not like him personally. I get it. Although I think if you really kind of pay attention to what he's doing, you may understand his personality a little bit more. I can tell you that I was not a Trump supporter until he got the nomination. And then once he got the nomination, I threw my support behind him because I knew he was the only chance we really had. And so I did support him in that respect, but I wasn't real fond of him personality-wise. Then I started watching him, and I realized what was going on. The man has a heart of gold. I'm convinced of that now. But he also has the soul of a warrior, so he's not going to let people step on him. And that's exactly the person we needed, because a lot of what we're dealing with is the propaganda coming from our media and the lies that are being spread. So I just wanted to share this with you to let you see that this person was expecting everybody to jump all over him for saying that. And that's not what we're about, because the movement is not about Trump, really. The movement is about taking back our country. Like I said, I wanted to share that with you. I'll leave the link down below, and you can go ahead and, read the comments yourself. You can send this person a DM or a tweet or whatever. But I do think that we need to encourage people like this. I have recently just seen tons of people, it seems like, every time I post somewhere, I see another tweet of somebody saying, yeah, well, I used to be a Democrat, but I'm not voting for them now. They're crazy. So I think it's really turning the table. And I saw a Rasmussen poll that said he had 40% of the black population. If he's got 40% of the black vote, wow, folks, that's huge. I mean, 20%, usually they said if he would get 20%, that would be enough to win the election. So 40%, wow. And then I got to give you a little bit of a giggle here, folks. Now, whether you believe in wearing masks or not, I don't care. Either way, I have an opinion on it, but this is just ridiculous. Okay, wearing a mask is one thing. This is crazy. Let me turn off the sound here, because the sound is not what's really... See, look at these people. They have masks on, but they put places to eat. Okay, what good does the mask do then? I gotta ask you. And the people that were doing this, you could see, they're like, what? So, come on. That's just wrong. Wrong. So if you're going to wear a mask, wear it right. And for those who want to see my version of a mask, I hope in the next couple of days I'm going to do my style of crochet mask and put it on my Garden Devotions channel. It's just kind of my way to say, yeah, this is what I think. So anyway, I wanted to share this with you because the Seattle police chief sent out this letter, and he tells business owners that, you know what? You're out of luck. You're on your own when it comes to the rioters, because the city council has tied her hands. The police do not have the tools to combat mob violence. Let me show you this. So it says, July 24th, dear business owner and or resident. So this is not just business owners, this is residents too. Please know that the Seattle Police Department is committed to addressing life safety incidents and calls for service and responding to ongoing demonstrations and unrest in the city. Please also know that the City Council ordinance, and there's the number, crowd control tool, goes into effect this weekend on Sunday, July 26th, 2020. This ordinance bans Seattle police officers the use of less lethal tools, including pepper spray that is commonly used to disperse crowds that have turned violent. Simply put, the legislation gives officers no ability to safely intercede to preserve property in the midst of a large, violent crowd. It is important to bring to your attention that yesterday I sent the City Council a letter ensuring them that as the Chief of Police, I have done my due diligence of informing them numerous times of the foreseeable impact of this ordinance on upcoming events. The letter is attached for your reference. And for these reasons, Seattle Police will have an adjusted deployment in response to any demonstrations this weekend, as I will never ask our officers to risk their personal safety to protect property without the tools to do so in a safe way. So, puts her in a really difficult spot. This must be kind of scary, really, for those police officers and for the residents and business owners. I don't know. I don't know what Seattle's gun laws are like, but if I were somebody living in that area or I had a business, I'd be stocking up on ammo right now. That's crazy. And Ted Cruz is putting out a bill that would address this kind of situation and would actually hold the state or the city responsible for any damages that are going to happen because they told the police to stand down. And essentially, they didn't tell them to stand down, but, when you take away all their tools, what are they going to do? Stand there defenseless and be attacked? I have a cousin who's in the police department in Anderson, Indiana. And, he had bottles thrown at him and everything. One hit him. So it's dangerous being a police officer. And, when I say bottles, I don't just mean like just a regular bottle. They freeze them so that they become really hard. And if you've ever been hit by one, you would know, okay? So anyway, with the insanity that's going on there, evidently Portland does have at least one sane judge. And wait until you see some of the stuff here. There's a suit that's been filed in the United States District Court for the District of Oregon, Portland Division. And it's Ellen Rosenblum is the plaintiff against John Doe's 1 through 10, United States Department of Homeland Security, United States Customs and Border Protection Service, United States Marshals Service, and Federal Protective Services. In other words, the federal agents that Trump has deployed to those areas to protect federal property. Okay, those are the defendants. So when it comes through, this is the actual decision. As I read through this, you'll get the gist. I'll explain it as we go because you got to hear what this judge is saying. Now, remember, this is the judge's opinion here. This is the decision that the judge made. In the wake of the tragic killing of George Floyd in Minneapolis, international protests have demanded fundamental changes to our criminal justice system, particularly to police culture and tactics. These important protests have, in Portland, centered on a 4-block area that includes the U.S. courthouse, known as the Mark O. Hatfield Courthouse. By virtue of it being a federal building, the law enforcement personnel involved are federal agents. One of the most difficult tasks for law enforcement in a free country like ours is to support robust protests while still maintaining order through lawful methods. This is even more challenging when the subject of the protest concerns police tactics. It is not unusual following major protests for some of the people involved to allege that the police crossed a line, a constitutional line, in the course of their interactions. It is also common for these interactions to result in lawsuits, with protesters contending the police violated their First and Fourth Amendment rights and seeking redress by money damages and injunction relief. There is a well-established body of law paving the way for such lawsuits to move forward in federal court. This is not such a lawsuit. Okay, now remember, this is the judge speaking. After hearing oral arguments and after having the suit presented to them, the documents. So this is the judge. This is not such a lawsuit. It is a very different case, a highly unusual one with a particular set of rules. In the first place, although it involves allegations of harm done to protesters by law enforcement, no protester is a plaintiff here. Instead, it is brought by the state of Oregon under a rarely used doctrine called parens patriae. In the second place, it is not seeking redress for any harm that has been done to protesters. Instead, it seeks an injunction against future conduct, which is also an extraordinary form of relief. Under the governing law for such cases, the state of Oregon must make a very particularized showing in order to have standing to bring a parens patriae lawsuit. A task made even more challenging by the nature of the remedy it seeks. Okay, wait until we get to that. That's like, what? You want them to do what? Because it has failed to do so, most fundamentally because it has not shown it is vindicating an interest that is specific to the state itself, I find the state of Oregon lacks standing here and therefore deny its request for a temporary restraining order. Okay, so they wanted to get a restraining order that would keep the federal agents out of Portland. Yeah. They wanted to stop them from being able to arrest anyone or whatever. So they wanted this, restraining order TRO is what they're going to call it later on, temporary restraining order. So anyway, you got to follow this. This is the procedural history. For about 8 weeks, these protests against police brutality and systemic racism have been a nightly occurrence in the area of the Multnomah County Justice Center, which includes the local jail, and the Hatfield Courthouse. At the beginning of July, Acting Secretary of the Department of Homeland Security, Chad Wolf, announced that his agency would deploy special units of officers to protect federal property. Reports from Portland media documented federal officers engaging with protesters at the Hatfield Courthouse as early as July 2nd. Within less than 2 weeks, reports surfaced that federal officers were grabbing protesters, pulling them off the sidewalks of downtown, and shoving them into unmarked vehicles. Now remember, this is what they're alleging happened. The state filed this lawsuit on July 17th, seeking to enjoin federal officers from continuing in that practice. So they want to stop the federal officers, the federal agents, from being able to make any arrests. The state filed this motion on July 20th with oral argument on July 22nd, and there you've got the minutes of the proceedings. I will refer to the alleged interactions between police and protesters as, quote, seizures, for purposes of this opinion because, while it is unclear whether they constitute arrests, detentions, or something else, they are seizures for purposes of the Fourth Amendment. The state argues that the alleged seizures are unlawful for several reasons. Now, this is what Oregon's saying, okay? They violate the Fourth Amendment rights of the individual being seized. They violate those persons' Fifth Amendment due process rights. They violate the First Amendment rights of individuals who wish to protest but are discouraged from doing so because they fear being seized, and they constitute a public nuisance. Okay? So they're saying that, well, you've got to have due process and you need a warrant to arrest them and everything. So, but the thing is, when it comes down to this, and you're going to see as it goes on, there's been no attempt to find out if there were any warrants or if they were, read their rights or anything like that. So there's no way that they can say that didn't happen. It's just the person saying, well, that's what they did to me. And you just have their word to go on. Yeah, okay. Anyway, let's go on. So, the state does not further its public nuisance argument in its motion for a restraining order. So, I will not consider it in the analysis below. Okay, so for some reason, this public nuisance part, they were calling about it, but they didn't continue on with it and ask for that. So, the judge said, well, I'm just not going to even deal with that. In the motion before me, the state is seeking a temporary restraining order that would impose 3 remedies. Okay, this is what they expect to have happen here. Number 1, a requirement that officers identify themselves and their agency before arresting or detaining any person. 2, a requirement that officers explain to any person being seized that he or she is being arrested or detained. And 3, an enjoinder against arrests that lack probable cause, because you have to have probable cause to arrest somebody. The state lists other remedies in its complaint, but as established at oral argument, these are the only remedies at issue in this motion. Okay? Before I begin my analysis of whether the state should receive its requested restraining order, I will resolve preliminary legal questions that underpin the analysis below. First, while the complaint paints a picture of numerous protesters being seized from the streets of Portland by unidentified agents, the state's evidence in its brief and at the hearing consists of just 2 examples. Okay? So it's 2 people who said this happened to them. First, it presents 2 declarations from an individual who claims he was detained by federal officers without probable cause. Second, and then it's got it there, the 2 different ones there. There is no video of this arrest and no evidence relating to its legality other than Mr. Pettibone's sworn statements. So in other words, the guy says, they did that to me, but there's no evidence that they did that to him. It's just this guy's word. That's all there is. Defendants have not refuted the state's allegations that Mr. Pettibone's seizure lacked probable cause. I therefore assume, only for purposes of this opinion, that this seizure was unlawful. Now, the reason that he's saying this is because the defendants, who are the federal officers, have not said, well, that's not true. And I don't know why they wouldn't have, but they didn't. So that's why he says, I therefore assume, only for purposes of this opinion, that the seizure was unlawful and constituted a violation of Mr. Pettibone's rights under the Fourth and Fifth Amendments. As its second example, the state has offered a video, which it states has been circulated heavily online, and which appears to show an individual being seized without any verbal explanation from officers. The video shows the seizure, but does not show any context for what preceded. This is the kind of judge you want. Somebody who goes, no, wait a minute. You don't know. It therefore does not speak to probable cause one way or another, because it is equally plausible that the individual was an innocent bystander, or that he had committed some criminal act just before the officers seized him. There is simply no way to know on the record before me, and I am not permitted to assume one way or the other. Again, this is the kind of judge you want, really. This is how a judge is supposed to behave. It is not, for purposes of this opinion, evidence of an arrest that lacked probable cause. The state argues that, regardless of whether the officers had probable cause for the arrest, the lack of verbal identification from the federal officers renders the seizure unreasonable for the purposes of the Fourth Amendment, because they need to identify themselves. Defendants argue that the officers were otherwise identifiable given their official uniforms and insignia, and that no verbal identification was required. They've been wearing these outfits that say police and real big letters across their chests. Whether these seizures are reasonable or unreasonable is a close legal question that I will not answer here. What I will do is assume, without deciding, that this seizure was constitutionally unreasonable, while stressing that this is not a legal ruling for purposes of future litigation in this case. In other words, the judge is not actually making a decision on whether that seizure was constitutional or not. What he's saying is, with the evidence that's been presented to me, this is the conclusion I have to make at this point. It's not going to make a difference in the ruling, though, okay? So don't panic, and he wants to make sure that they know that's not, if you bring the case before me, that doesn't mean I'm going to rule that way. Taken together, for purposes of this opinion, the state has presented just one example of an arrest without probable cause and one example of an unreasonable seizure. So that's what this is all about. They make it sound like it's the entire state. Oh, we're doing this for the whole state of Oregon, and we are respecting all these people's rights, so we're representing them. And it's like, no, it's two people, okay? That is the sum total of the evidence before me that underpins the legal injuries the state asserts in its brief, and that I address below. Notably, the state does not request any relief with respect to defendants' use of unmarked vans, a fact that has been widely reported in both local and national media. The use of unmarked vehicles is therefore irrelevant to the legal analysis that follows, and I do not consider that practice at all. The relief sought here has only to do with verbal identification of officers and probable cause, and my analysis focuses on that relief alone. So then it goes on. The legal standard for a temporary restraining order, and that's where they give the initial TRO, and then it's referred to later on as that, is essentially identical to the standard for a preliminary injunction. A preliminary injunction is an extraordinary and drastic remedy, one that should not be granted unless the movement, by a clear showing, carries the burden of persuasion. In order to meet that burden, a plaintiff seeking a preliminary injunction must establish that he is likely to succeed on the merits, that he is likely to suffer irreparable harm in the absence of preliminary relief, that the balance of equities tips in his favor, and that an injunction is in the public interest. Okay, those are the things they have to meet. That's the criteria right there. So that's what they're looking at. In addition to meeting these requirements, as a threshold matter, a plaintiff must have standing to sue. Okay, when they talk about having standing, that means that they must be the right person to sue in this case. And if I remember correctly, there was a court case with all the evidence necessary to show that Obama's birth certificate was not legitimate. And there was a question about his legitimacy and his eligibility for the office of president. And they threw it out of court. The judge said that he believed there was sufficient evidence, but that the person bringing the suit did not have the legal standing. And that the only people that could have brought the suit that would have had the standing was the Democrat National Committee. And yeah, they weren't going to do that, right? So I just wanted to toss that in there. And I believe also there was a suit by the Bernie Sanders people after the last election, the presidential election in 2016, and they were wanting to say that, they got cheated out of things because of how Hillary did things. And I believe in that case, too, that it was dismissed because it was ruled that they were not the proper people, that they didn't have standing to bring that case. So, it happens. It definitely does. And they say, yeah, well, you may have a case, but you're not the person to bring it. So that's what he's saying here. And he says, okay, as standing is the dispositive issue in this case, I take up that analysis first without reaching the question of whether the state has met its burden to prove the merits of its motion for a TRO. Two features of this case make the standing analysis unusual. First is the fact that in a typical case alleging these types of constitutional harms, the aggrieved individual would sue on his own behalf. Remember the two people that supposedly had their rights violated? Yeah, they're the people that should be bringing the suit, not the state of Oregon. Okay? Here, however, the state of Oregon, by way of Attorney General Ellen Rosenblum, has brought a suit alleging these same kinds of constitutional claims on a theory that they harm the state's citizenry writ large. Second, Oregon does not seek to redress past harms, as it would be the norm in an individual claim of this type, but rather seeks to enjoin future conduct. Both of these features, the identity of the plaintiff and the nature of the requested remedy, render the standing inquiry an unusually high bar to clear. So he's trying to say, you know what? You really are pushing it on this whole standing thing. The plaintiffs should have been the actual people that this happened to, not the entire state. And it's the Attorney General for the state that is doing this. And so this parens patriae, Oregon asserts that it has standing to sue on behalf of its citizens under a doctrine known as parens patriae. In order to assert parens standing, a state plaintiff must plead an injury to its citizenry that meets the usual Article 3 requirements, that it be concrete, particularized, and actual or imminent, fairly traceable to the challenged action, and redressable by a favorable ruling. It must also meet two special requirements. First, the state must articulate an interest apart from the interests of particular private parties, i.e., the state must be more than a nominal party. Second, the state must address a quasi-sovereign interest that has been violated. The category of interests that qualify as quasi-sovereign is relatively broad. It includes, as the two primary categories, the health and well-being of a state's citizens and the state's right not to be discriminatorily denied its rightful status within the federal system. Here, the state has asserted a quasi-sovereign interest in the civic and physical well-being of its people to be free from violations of their constitutional rights, and it alleges a series of injuries to its citizenry that implicate that interest. So they're really pushing it here because they're trying to say that, well, we must protect our citizens. Now keep in mind, this is Portland, folks. What's been going on in Portland? Have they cared about their citizens there? Oh no, they're about like Seattle, where you had the letter I just did that told the police, yeah, we're not going to allow you to use anything to go out there and protect yourselves, so I guess everybody's out of luck. See, this is what is so hypocritical. They claim that they're protecting their citizens with this, and it's like, no. Why don't you go downtown and stop people from burning and looting and hurting other people? That would be protecting your citizens. Oh, it's so frustrating. The Fourth Amendment. At the highest level of abstraction, the state argues that it has a quasi-sovereign interest in protecting its citizens from unlawful seizures, which is the Fourth Amendment. This argument is not fleshed out in the briefing, nor did the state do so at oral argument. Presumably, the state's theory is that the state of Oregon is harmed when its citizens are subjected to widespread, unlawful seizures of their persons. While it is arguable that this could be a quasi-sovereign interest to support a parent's theory of standing, it is highly unlikely that it would do so in a case with no more than 2 identifiable unlawful seizures. Now, if it was happening to a big bunch of people, that might be a different case. But it's 2 people. 2, count them, 2, 1, 2. But in any event, this argument fails to confer standing for the state to seek an injunction, which I address in greater detail below. Most specifically, the state asserts a 2-part injury in its quasi-sovereign interest in protecting its citizens from unlawful seizures. 1, that Oregonians are at greater risk now of being victimized by genuine kidnappers. This is the part you got to listen to, folks. Really. And 2, that Oregonians are at a greater risk of violence by the police if they reasonably resist what they believe to be a genuine kidnapping when they mistake federal agents for kidnappers. Yes, this is what they're doing. The state's theory, okay, it's a theory, is that individuals who oppose the protests could assume the attire of federal police and mimic these unlawful arrests in order to kidnap protesters, thus subjecting them to the risks discussed here. Really, they think the people that don't like the protests are going to dress up like federal officers and go and kidnap these protesters. I guarantee the last thing on my list is kidnapping protesters. Oh my goodness. This is so full of fiction. I don't know how this judge would have kept a straight face reading this. It was just like, what? This is what you want? Oh, it gets better. The state reasserted this theory at oral argument, insisting repeatedly that it had an interest in protecting its citizens against the potential for kidnappings, both real and mistaken. This 2-prong injury rests on a public health and welfare theory of parens patriae that seeks to vindicate the constitutional rights of Oregon's citizens, and it meets the requirement that it be independent of the interest of any one individual. It does not, however, satisfy the requirements of Article 3 because it is purely hypothetical and fictitious. In order to sue in federal court, a constitutional minimum of standing must be met. Okay, now, this one they're going to talk about, this Lujan here. They're going to talk about this one, and basically it's about this minimum. That minimum requires 3 elements to be satisfied. 1, the plaintiff must have suffered an injury in fact, i.e., an invasion of a legally protected interest that is concrete and particularized, as well as actual or imminent, as opposed to conjectural or hypothetical. It'd be like, oh, what if aliens come down and abduct us? Oh, no! I mean, it's just crazy. We should be able to sue the federal government if they don't protect us from aliens that will abduct us. It might as well be that with all of this that they're doing. Really, seriously, it's like that. Number 2, there must be a causal connection between the injury and the offending conduct. And 3, it must be likely that the injury will be redressed by a favorable decision from the court. Okay, so those are the 3 things that they have to do according to this Lujan. Plaintiffs bear the burden of proving all 3 elements. Oregon's asserted interest fails the first prong of Lujan because the injury the state asserts is completely conjectural. First, the state candidly admits that it does not have a shred of evidence that counter-protesters have ever, anywhere, kidnapped a protester or anyone associated with protests. Second, the asserted interest rests on an utterly implausible inference. The state's reasoning is that counter-protesters, once they learn of seizures of protesters by federal agents, will dress up like police and go out on private missions to kidnap protesters. This despite the fact that such kidnappings are Measure 11 felonies in Oregon, punishable by mandatory minimum sentences of up to 70 to 90 years in prison. I do not discount the animosity among these groups, and had I been asked to assume that something would result in fistfights or theft or destruction of signs or damage to vehicles, that would have made sense. But the idea that seizures by law enforcement will lead to kidnappings by private parties is a bridge too far. I guess. I mean, it's just crazy here. I put in a similar category the state's asserted interest in preventing a spate of cases in which protesters mistakenly think the federal agents who are seizing them are actually counter-protest kidnappers. Again, there is no evidence to support such an assertion. The state has not pointed to any instance in which a protester was subjected to state violence because she believed she was resisting a kidnapping. In both instances of a federal seizure, it is either admitted or clearly visible that the agent's uniforms say police. I told you, they say police on them. The state further admitted at oral argument that, to its knowledge, counter-protesters have never dressed up as police. Oh, yes, of course, we don't, because we respect the police. Finally, the state's asserted interest here fails the third prong of Lujan, redressability. Oh, get this one. The state's requested solution to the kidnapping problem is to require actual federal agents to verbally identify themselves as such, presumably guaranteeing that they are the real deal. But if one is willing to go along with the state's concerns about copycat kidnappers, it requires me to assume that such nefarious characters are willing to dress up like federal agents and willing to commit the very serious crime of kidnapping, but that they would blanch at the thought of identifying themselves as police. The requested remedy here is a linguistic Maginot Line and of no use in the real world. Oh, it's just so crazy. Okay, now let's deal with the First Amendment. Elsewhere in this briefing, the state also appears to assert 3 other harms to its citizens that violate its interests in their well-being. 1, a chilling effect upon its citizens' First Amendment rights of free speech and assembly. Yeah, what about the rights of the people that don't agree with what they're trying to promote? What happens to them? I bet they are feeling a chilling effect right now. Number 2, a diminishment in public confidence in law enforcement. And 3, a significant cost to the state in prosecuting kidnappings after the fact. The second and third of these alleged harms must be dismissed for the same reasons described above. They are both hypothetical, with no evidence in the record to support either of them. In fact, the state did not address its confidence in law enforcement theory at oral argument or anywhere in its briefing other than the passing reference noted here. The chilling effect injury comes closest to satisfying the Article 3 standing requirements described above. It is the only one of the alleged harms that has any evidentiary support in the record. At argument, however, the state seemed to assert this interest on the theory that speech would be chilled by the fear of kidnappings. This theory creates a problem under the third prong of Lujan, similar to the problem with the state's alleged interest in Fourth Amendment violations, which requires that the alleged harm be redressable by the remedy that a plaintiff seeks. The injury, the state asserts, a chilling of its citizens' speech, is not actually redressable by the requested remedy, given that citizens could still believe they might be kidnapped even if police are required to verbally identify themselves. Apparently, the word police and other official insignia on uniforms has not quelled this fear among the public, and it is highly questionable whether the requested relief would do so either. More fundamentally, the chilling effect injury presents a problem for the state under the parens patriae doctrine. While the state has asserted a quasi-sovereign interest in the civic well-being of its citizens, and the chilling effect injury is a violation of that interest, parens patriae also requires that the state's interest be more than a nominal interest in an individual dispute. In other words, it must be a harm to the state and its citizens more broadly. This is the problem with the chilling effect injury. Oregonians, like all Americans, have individual rights to freedom of speech and assembly conferred by the First Amendment. They can, and often do, bring individual lawsuits to vindicate those rights. And the state of Oregon has not explained why this case is different, why the chilled speech it alleges here injures the state in a way that is distinct from the individual harms that it also alleges. Perhaps there is an argument or a theory that could draw this distinction. The state did not manage to do so in its briefing or at oral argument. And I find that this interest, while it may or may not satisfy Article 3, does not satisfy the requirements of parens standing. So, it's like, no, you can't do this because it's only affected 2 people. Okay? Now, if it affected a big bunch of people in the state, that would be different. But no, it didn't. Just 2 people. So, what do they want? Injunctive relief. Even assuming arguendo that the state had pleaded parens patriae standing, it does not have standing to seek the specific remedy it requests. Through its motion, Oregon seeks a temporary restraining order that would require defendants to identify themselves and their agency before detaining or arresting any person off the streets in Oregon. Explain to any person being arrested or detained that she is subject to arrest or detention, and explain the basis for the seizure, and to refrain from arresting protesters without probable cause or a warrant. Even if the state had parens standing to vindicate broadly its citizens' First and Fourth Amendment rights, or standing on a theory of one of the more specific injuries discussed above, any formulation of its quasi-sovereign interest would fail to confer standing to seek an injunction because every theory rests fundamentally on the idea that the unlawful seizures described above violate citizens' rights. The state simply does not have enough evidence that those unlawful seizures are likely to continue. We don't even have evidence that they even happened, that they were illegal. Because how do you know that they didn't read those people their rights? How do you know they didn't have warrants? Or how do you know those people didn't commit some kind of crime that they were lawfully arrested for? We don't know. Okay? And I'm sorry, just having one person's sworn statement that that's what happened is not enough. That's not evidence. That's just one person's opinion, and they have every reason to make law enforcement look bad. Standing is a remedy-specific inquiry, and this one right here, holding that the plaintiff had standing to pursue damages for his past injury, but lacked standing to pursue injunctive relief to prevent future harm. Past exposure to harmful or illegal conduct does not necessarily confer standing to seek injunctive relief if the plaintiff does not continue to suffer adverse effects. And if you look at this one, in other words, injunctive relief requires more than a showing that a plaintiff has been harmed. It requires a showing that she will likely be harmed again. And an injunction is unavailable absent a showing of irreparable injury, a requirement that cannot be met where there is no showing of any real or immediate threat that the plaintiff will be wronged again in a similar way. This case is nearly on all fours with Lyons, the case they were just talking about. In that case, the plaintiff was subjected to a chokehold by City of Los Angeles police officers, and he sought injunctive relief to prevent them from using chokeholds in the future. The United States Supreme Court held that he could not seek injunctive relief because he had no evidence that he would be subject to an unconstitutional chokehold again. The court provided two primary examples of how a plaintiff could show the required real or immediate threat that he will be wronged again. Either one, that all police officers in Los Angeles always choke any citizen with whom they happen to have an encounter, whether for the purpose of arrest, issuing a citation, or for questioning. Or two, that the city ordered or authorized police officers to act in such a way. Of course, neither one of those is something they're going to be able to show, right? The same is true here. The state has alleged that the purported illegal seizures by defendants have caused an injury to its citizens' rights to speech and assembly. In other words, the state must show that the illegal seizures, analogous to the chokeholds in Lyons, will occur again in the future. The state could try to show, for example, that all of defendants' seizures are illegal. In other words, all the seizures that the agents are doing are done illegally, that they're illegal, or that they are under orders to fail to identify themselves or make random arrests without probable cause. And we know that's not true. The state has shown none of this. It has presented no evidence of any official orders or policies, and has presented no evidence that these alleged illegal seizures are a widespread practice. Despite the broad language in the complaint, Oregon has shown at most that this type of seizure has happened twice. At oral argument, when asked what evidence it could present to show the likelihood of future harm, the state pointed to the fact that defendants have defended against this lawsuit. So because they were being sued and they got a defense attorney and everything and were trying to defend against it, that proves it. See, that proves that it's going to happen again. It's like, what? No. Not only is defending a lawsuit not evidence of constitutionally unlawful behavior, it is not sufficient to support the showing the state is required to make under Lyons. The state's argument, regardless of how it's framed, rests on too little evidence to satisfy Lyons. The state has not met its burden to show that it has standing to seek injunctive relief, and I find that it does not have that standing. The state's motion is therefore denied, as a temporary restraining order is unavailable on the record presented here. And so that's what this one put down on the 24th of July. This is Michael M. Mosman, who is the U.S. District Judge there. But I got to show you this too, because I thought this was pretty good. In its briefing and at oral argument, the state described what has happened here in Portland as disappearance squads and disappearing people. Now, there's a reason that they're using those terms. And it says here, this is apparently a reference to the disappeared, los desaparecidos, which were the 30,000 people who were tortured and murdered by the Argentine military junta 40 years ago. That's what they're called, the disappeared ones. Even taking every word of the state's arguments and evidence at face value, this seems out of proportion. So see, that's why they've been using that terminology, the disappeared ones, the disappearance squads, because they're trying to connect it with what happened with those people in Argentina. So, we're talking 30,000 people, and it was just a lot of people that disappeared during that time. and nobody ever knew what happened to them. So there's a lot of them that have happened in South America and also Central America. You're getting a lot of people that just kind of up and disappear. In fact, I did a video when the caravans were coming up through Mexico, and I pointed out that one article said that there were 2 busloads of people that just kind of vanished. Nobody knew what happened to them. And evidently, nobody seemed concerned enough to dig into it. So, just thought I'd point that out. That's what they're doing. And so, that is the document. They were denied, okay? I don't know if they can appeal. I assume they can. But for now, this judge, smart judge, somebody who takes a stand and actually judges the way they're supposed to judge, because he looked at it and said, you know what? You aren't the people to bring this. If somebody was wronged like that, if these 2 people were wronged, then these 2 people need to bring the case, not the Attorney General for the whole stinking state. Anyway, so I'm going to end with this one, just in case you haven't seen it. I thought it was really unusual. In Virginia and Utah, evidently, people are getting these seeds, packets of seeds with Chinese writing on them. They don't know where they came from. They're just like randomly receiving these in the mail, I think it is. And it's just kind of odd that that's what they're doing. So if you happen to get random packets of seeds from somebody, don't plant them, okay? Because nobody knows what kinds of seeds they are. They could be invasive, species that could be a real problem, and you don't know. Nobody knows. Nobody ordered them. They just get these. And actually on the package it says that they are earrings or something like that. Can't remember where it says. Yeah, that it contained earrings. So something's up. Something's going on. Not sure what it is. But if you get any seeds and you didn't order some and they have Chinese writing all over them, don't plant them. Okay? In fact, really don't even open the package. You probably need to take it to authorities because who knows what's in there, right? Anyway, that's what I've got for you on this one. I want to thank you for stopping by, and I'll see y'all later.